Good morning, and thank you very much for joining us. I am Yori Folari. Well, my guest this morning is Mr. Ibrahim Lawal. He's a lawyer and public affairs analyst. And, well, the reason we sort of need a legal mind, is that we want to look at the court nullification. As you recall, Justice Emeka, Justice Emeka Nwite, he nullified, the candidature of the Osun State governor in the last governorship election because Memala Buni, who submitted the names, had violated certain aspects of, provisions. But long story short, he's nullified the candidature of the governor. And as I said, our guest this morning, Mr. Ibrahim Lawal. Can I say a good morning to you? Thank you very much for making the time for us. Mr. Lawal. Okay, Mr. Lawal. Okay, yes, you are there. Did you hear me? Good morning, Mr. Lawal.
Said good morning. It's nice joining you.
Aha. Okay, then. It's a pretty serious matter, especially to those concerned, the players concerned. And I don't know, that was like maybe out of the blue. But hey, there is always a legal way in which people look at things, or in which things should be seen, perhaps. So I wanted to ask, first of all, give me your general impression about Justice Emeka Nwite's declaration that the governor, Isiaka, Adeleke was not actually a properly nominated candidate.
Well, the judgment of Honorable Justice Nwite came to us as a surprise because in the hierarchy of courts, the higher court, the Court of Appeal and Supreme Court, when they have settled the matter, it is incumbent on the lower court to follow such decision. This matter that Justice Nwite, ruled upon had been settled in the case of Ondo State governorship election petition that involves the PDP, who is also the plaintiff in this matter. That's a case of Eyitayo Jegede and INEC. The same issues the learned son submitted to the court was that Governor Buni, being the governor, cannot also exercise another executive power. And the Court of Appeal and the Supreme Court said emphatically that the issue of signing of nomination by a political party is just a notification to INEC that the issue of sponsorship and nomination starts and ends at the at the state congress, where party members, make their preference as to who is the candidate of that of the party. That one is a mere notification, and it cannot affect sponsorship of that candidate. That issue we brought to the attention of the Honorable Justice Nwite, that on the strength of this decision, the court cannot hold otherwise, that action is not properly constituted.
Secondly, before you go, sir, are you referring all of that is as it relates to Section 183 of the Constitution that was cited as having been infringed upon? Okay.
Yes, Section 183 of the Constitution that was cited has to do with any person holding an executive position can also exercise other executive position. If you look at what constitutes executive position, which the Supreme Court had rightly said to, chairmanship of a political party is not also one of it. the executive positions are listed in the Constitution itself. So it will be wrong of anybody to go, outside that Constitution. And also, there are plethora of cases that the Supreme Court had settled that what affects the qualification or disqualification of any persons to contest for governorship of any state or the president is Section 177 of the Constitution, that you cannot add or subscribe or, subtract from that provision. And the provision is very clear. So it has nothing to do with it. Like I said, all these issues were issues that had been trashed by the Supreme Court. Even, and there are plethora of authorities that say that when a higher court have taken a decision on a matter, and another matter is brought before them with the same issue, the lower court is bound to follow that decision, even if that decision is wrong. It is not for the lower court to deviate.
Okay.
So to us, we felt that judgment was given par incuria,
which is Latin for.
And what is
which
more,
is Latin
we
for.
also have the right of appeal. That is just the court of first instance.
Okay. All right then. So you were going to go on to.
It's a court of first instance. Let me give you an example.
Sure.
Let me give you an example. When this the governor that defected to APC, and the PDP went to court, and the court nullified that defection and said that the governor has ceased to become governor until that he has stopped to become governor because the party through which he was voted, he has decamped, contrary to decision in Atiku Abubakar and Obasanjo that time. They went on appeal, they nullified that judgment and said that it is a judicial rascality for anybody to want to overrule decision of the Supreme Court, particularly the lower court.
Okay.
So that's just the similitude of what is happening here. We are very sure that when we get to appeal, it is going to be set aside.
Okay.
More so, election matters. When decisions are taken in the lower court, it does not necessarily matter that effect will be given to such decision. Let me give you an example. In Bayelsa case, Leon, just like the case Leon lost at the lower court. He remained the candidate of the APC until the final determination at the Supreme Court. In Ogun State now, if you check the list of governorship candidates of the party, it is still Adebutu of the PDP, despite the judgment of the Federal Court that had nullified their primary, because the matter has not been, finally determined. So, in whichever way you look at it, the fact that they have gotten a judgment at the lower court does not mean that there is still no candidate. Oyetola still remains the candidate until the final pronouncement of the Supreme Court.
Okay,
so that is no cause for alarm.
The ultimate, if it goes up to there.
There are windows of opportunities.
Okay.
To still test, to still test the decision in the Court of Appeal as well as the Supreme Court.
Okay. But before I interrupted you to get some clarity on the constitutional aspect of it, I think you were going to go on to explain how the learned, or shall I say the Honorable Justice, sort of figured out that Section 82(3) of the Electoral Act had been breached as well.
Like I said, Section 82 of the Electoral Act was not in any way breached because there are judicial pronouncements, like I have said. We are talking about for somebody to qualify to stand for election, it must, be sponsored by the political party. And like I have told you, by Supreme Court judgment, the majority judgment of the Supreme Court, Agim JSC, said that the issue of nomination of candidates rests squarely with the members of the party. That the communication to INEC by the national body or the chairman or the secretary of the party is just a mere information.
Okay.
That is not the sponsorship or the nomination. And as such, you cannot, on the basis of the fact that somebody signed and now nullify the efforts of people in that state to have agreed to nominate a particular person as their candidate. And if you look at that reasoning, it accords with common sense. And the Supreme Court went further to say that the fact that somebody had even wrongly, assuming without considering that the Malabuni did not even have a right to sign, that the fact that he signed, there is nothing in that law that prescribes sanction for that infraction, and as such, cannot the candidate cannot be made to suffer. That the party are taking a decision at the state congress, and that ends it. That is just a mere communication.
Okay.
What is more, even when during the hearing, the document they sought to nullify, which they said Buni wrote, was not before the court. Throughout the argument of the case, it was after the counsel to Oyetola and the APC pointed out that even the document they sought to quash was not before the court, and the arguments were taken and everything, and the judgment was the matter was adjourned for judgment. That the plaintiff now filed a further affidavit to bring in those documents, and there was a counter affidavit to say that you cannot bring a document when you have closed your case. You will need the leave of court to reopen your case if you want to introduce further evidence. The court did not pronounce on it, which is fatal. We also raised, as part of the preliminary objection, that they were out of time to bring this matter before the court. Section 285 is very clear, of the Constitution is very clear as to when to file a pre-election matters. You have to file within 14 days. The letter communicating the candidature of Oyetola to INEC, written by Mai Malabuni, was done on 18th, was received by INEC on 18th March. And this matter was not filed until April, which was clear out of 14 days. But in the reasoning of the judge now said that it was when the nomination was published that the time begins to run. And we disagree with him. When a publication is done, it is to see whether those facts that had been supplied by candidates are false that you can take to court. But the issue of nomination, it starts from the day that nomination was sent to INEC and when INEC received it. Anything outside that time, the matter is clearly statute barred. These are issues we have submitted, to INEC, and unfortunately, his lordship ruled otherwise. That's why I said there are windows of opportunity for us, which we are very certain, because the law is very trite.
Okay.
That the matter that had been, settled need no further argument. We are fortified by the decision, just a last year decision. The same issue, the same person who signed that nomination form in Akeredolu's case was the same person they are challenging. So we are very sure that this judgment is going to be set aside.
Okay.
On that authority.
Okay.
So we have no cause to fear anything.
Well, okay. Because well, as you've explained it now, it was, you were quoted more dramatically in the press as saying that the court judgment against APC primary as dead on arrival. But you've explained it.
Yes.
But that's why I'm so sure for the reasons you've just enumerated. As you said, windows of opportunity exist.
Exist. We have opportunity to test this decision in two other courts, in the Court of Appeal and in the Supreme Court. I am so sure that by the time we get to the Court of Appeal, on the authority of Itayo Jegede and the INEC, we are going to get judgment. We are going to set aside this judgment. They cannot stand.
Let's hear from a viewer at home. Mr. George is in Ikeja. Good morning, Mr. George.
Sorry. Uncle Yori, as the 2023 election approaches, I think the judiciary must shape up. What do I mean? The Chief Justice of this country also needs to sign a peace accord. Uncle Yori, I smell a rat in this judgment. Why? Before the Osun election, the same Governor signed the one to INEC from Ekiti State. That one did not bring any issue. I've been following the tribunal proceedings about the Osun elections, which is still going on. And I can also foresee where it is tilting. I believe that it is because of that somebody somewhere is trying to use a technical point to knock down Oyetola. We must be sincere if the project Nigeria is going to materialize. I'm calling on the president that in order to make 2023 free, fair, and bring progress to this country, the judiciary must be carried along and the judiciary must key into the project. Therefore, the Chief Justice of this country needs to sign a peace accord. Good morning.
Thank you very much for calling in, Mr. George. Well, the way that viewer, do you care to comment on the way that viewer phrased his comments and the need for a quote-unquote peace accord, that the CJ needs to initiate?
I just want to say that, the reality about our judiciary is that the judiciary must be alive to that and know that laws that are settled need not to be, tampered with. They started with the Umahi case and wanting to remove Umahi through the courts until the Court of Appeal came to the rescue, despite, established, principle of law. People should know that they owe the society that responsibility to ensure fairness in whatever they do.
Okay. Good morning, Benga in Abuja. Good morning. Go right ahead, please.
Good morning, Mr. Yori. Good morning to your guest.
Thank you. Good morning.
When I heard about this judgment, I was taken aback. It looked appalling to me because looking at other judgments in regard to this, I believe that the Supreme Court judgment is final, but it has said to all this because in the case of Akeredolu and the PDP candidate, it was the same case that was brought before the Supreme Court. And they said, no, you cannot judge us because, number one, the governor of Yobe State, Mela Buni, is a sitting governor. You can't make him a part of a case in court as a party. Because that's what our law says, that they're immune against any institution, any case in a party. I'm not a lawyer. And I'm going to ask, in this case now against this governor, was Mela Buni, the governor of Yobe State, part of is he a party to it? If it's not a party to it, then why should you not a judgment? Because he's the one that signed that thing, and you are saying that he should not have served, he can't serve as an executive position in two places. Is he part of the party? He part of the party. Then how do you bring a serving governor immune from every law court to before it's a court? I wonder why that court even had jurisdiction over that case before. By law, the court now will listen to them because the principal party there, Mela Buni, is immune against any court cases. Based on my understanding as a layman. So based on that, I don't see this case going anywhere. That's my conclusion. Thank you.
Thank you very much for calling in. Okay.
Yeah, let me just make a clarification.
Sure.
In this one, what they did in this one was that they made Mai Mala Buni a party. But being a party was not even the only thing that the Supreme Court said about that judgment. They settled the issue of what they did. What they said was that Mai Mala Buni signing nomination does not in any way affect the nomination. That it was just an information. It is not that the national body signed a letter to say that this is the candidate for the state. These are candidates for the governorship election in the state. It's a mere communication. They have said so. The Supreme Court has said so. So it's not whether they join Mai Mala Buni or they did not join. It has nothing to do with decisions that have been settled by the Supreme Court. They join Mai Mala Buni here, but that does not in any way detract from the settled position of the law as stated in the majority judgment of the Supreme Court. Some might want to argue that there are minority judgments, but there are plethora of cases that says that majority judgment is the judgment of the court, not the minority judgment. Minority judgment can as well, be seen in the light of the fact that they are minority. But majority judgment is the judgment of the court. So when you want to rely on the judgment of superior court, it is the majority judgment that you will rely on. So
okay.
that's the issue about nomination of Mai Mala Buni.
Okay, thank you for that clarification as it regards that particular aspect of whether or not he was a party. And Uche in Abuja also wants to join the program. Good morning to you, sir.
Yeah, good morning, Chief. Good morning, Chief Dr. Yorin.
Yeah. Good morning.
Yeah, good morning, sir.
Good morning. Please continue.
Yeah, good morning, the other guest.
Mr. Lawal.
Yeah, this is Uche. I'm calling from Abuja right now.
Okay.
Yeah, Mr. Yorin. That judgment in Osun, rather in Ondo State, people did not really understand. This man, the PDP candidate, he only assumed that Akeredolu is immune. It was when they went to the court that the Supreme Court said, had it been that Mai Mala Buni was addressed on that case, that Akeredolu would have, he would have relinquished his position as the governor. And even Akeredolu, from that point, started, even Festus Keyamo said something about it, and everybody was saying, and so some people were saying that they want the judgment. But if you look at the technicalities of that judgment, you will understand that had it been the PDP, it started the name of Mai Mala Buni, and that case, that would have been, the APC exit. And people up to now did not understand that. They thought that once you are a governor, there is not in everything that immunity covers a governor. It's not in everything. People should understand that. It's not in everything. Like for instance now, if you can establish that your governor does not have a certificate now, you can establish it now. That a court can throw away the governor out from the office at any point in time. So it's not in every case that people say that the governor has immunity. Governor has immunity. It's not in every case. That is my point. The only error that they made is that they just said APC. The PDP in Ondo, they just say APC.
They're just going down, down, quieter and quieter. I can't hear. I'm so sorry, Uche. But I think we got the body. We got the bulk of what you were talking about. And Mr. Lawal, I imagine that you also need to clarify some matters. But I really have to go off on...
Mr. Yori,
Yes, sir.
Mr. Yori.
Yes, I can hear you.
Mr. Yori.
Yes.
Yes, I listened to the last commentator, and unfortunately, what he said was not the true representation of what the Supreme Court said. I read the judgment. In fact, with due respect to my learned senior, Keyamo, when he made that statement, when the decision was added down, he has not read the judgment. I can assure you that if he had read the judgment now, if it was what happened, the PDP would have gone to court in Ekiti to also challenge the nomination of our governorship candidate. That was not what the Supreme Court said. The Supreme Court said that the decision to sponsor a person as the candidate of political party for a general election is taken by the relevant Congress or convention of the political party at a primary election of the political party held to nominate or select its candidate for the election. I am quoting, Supreme Court verbatim now. At a primary held to nominate or select its candidate for the election. In the case of sponsorship of a person as a candidate of a political party for the election of governor of a state, the decision is taken by the members of the political party in that state.
All right.
At a state congress.
Mr. Lawal, I do beg your pardon. I think we're going to have to continue this when I come back from the break, if there's a bit more that you need to explain. Thank you very much for staying with us. Okay, we'll be right back. Okay, welcome back. And we're looking at the court decision, the ruling of the Federal High Court and Justice Emeka Nwite, to the effect that the governor of Osun State was actually not properly nominated as a candidate. And so we've been speaking to the lawyer who has said that he just doesn't understand how that decision came down. It was a shock, and that, as he put it discreetly, there are many opportunities to pursue this case. He feels very, very sure that it will be overturned once it gets to a higher court. But we have a call waiting. Good morning, Mr. Mohammed in Abuja. Oh, Mr. Mohammed is not online anymore. Maybe you can call back in. Good morning to you, Ada.
Ada from Johnson.
Good morning, madam.
Wonder shall never end. You see, the problem is this lack of internal party democracy. Let political parties improve on it. Once they can improve on it, all these litigations will drop, if you ask me. I don't know if there's a way they can even amend the constitution. Some of these cases will just stop at the appeal court. All this, every little thing you cough, you go to Supreme Court, it's becoming ridiculous. They are overworked. I don't know. Honestly, it's really embarrassing. Very soon now, I'm very sure by the time the week runs out, you might take out the one of the senatorial seat in Ebonyi State. You can imagine all those kinds of, reckless way of doing things in the political parties. It's becoming unbecoming, honestly, the way it is now. And I don't know the kind of, authority they have. Because sometimes I get puzzled when people make those requests to them. They will now say, until they hear from the court. So what powers do they have? When it is obvious they did not even supervise a primary or whatever. And yet they cannot stop that name from being, published in public. So they should go back to the drawing board and review these things. It's becoming one too many, becoming very embarrassing. All the same, let's not give up on this country. It shall be well.
Thank you very much for calling in. Ada from Jos, getting a bit exasperated with all these actions that do follow in the wake of an election. Our guest is one of the counsels to Governor Isiaka of Oyetola of Osun State, and he's been talking to us and looking into the technicalities of it. And he says that, as I said earlier, there are quite a number of windows of opportunity for them to, instate the status quo, which is that the governor is indeed properly elected. Was indeed the properly elected candidate of the PDP. The lawyer has said, as you would have heard if we've been together from the beginning of the program, effectively, as one newspaper quoted it, the decision was dead on arrival. Mr. Ibrahim Lawal, well, while you were away, so to speak, somebody called in, Ada called in from Jos, and her point was that it's getting too frequent, and that is, all these actions that are taken to the judiciary, electoral matters that are taken to the judiciary for resolution, is getting to be a bit, a bit too frequent. And she blamed it squarely on what she referred to, using her words, as the lack of internal democracy. Okay, hold that thought, and let me take on Mohammed in Abuja as well, so we'll hear what Mr. Mohammed has to say. Mr. Mohammed, thank you for calling back. Good morning to you, sir.
Good morning, Uncle Yori. How are you?
Very well, thank you. Please go ahead.
Yeah, I thank your lawyer, Mr. Lawal.
Okay, Mr. Lawal, yes.
Thank you for his explanation and whatever. But what I want to remind people that I believe this case was heard in Supreme Court before, that Buni-led administration was duly constituted by the National Working Committee. They ratified his administration, and then they gave him all the powers that a chairman can exercise. So I believe this judgment in Osun, it has something undertone. So they need to follow that judgment. And then I want to appeal to the Supreme Court, to the NGC, or the Chief Justice of Nigeria. Let him be punishing those type of judges that are issuing judgment after Supreme Court has already had such cases. Please, I'm appealing. Let them be punishing them so that they will not be giving contradictory judgment like that. Because the issue in Osun was settled before even election. Before the election, they settled that issue of Buni-led administration of conducting primaries of Ikiti and Osun. If you remember, because we are following the happenings concerning the party, more especially APC party, because we are APC members. So we are having interest. And I believe that Okulori, I want to beg Benga from Abuja, he is from Lakal. Let him be calling 95.1, please. Let him be calling. Let him insist be calling, contributing his own quota. We love him. We want his contribution to continue. Let him be contributing in that radio station in Abuja. He knows the radio station I'm talking about. We are members there. Yep. So let him be calling, please, because they suspended him there. Let him be calling because they are now bringing some that they suspended before. Let him be calling because they feel that he's backing the president every time he's backing the APC, backing the president. Let him be calling that station again. Please, I'm appealing to him.
Okay. Well, thank you very much, Mr. Mohammed, and especially for trying to get back, which indeed you were successful with. Mr. Lawal, okay, you've heard Mr. Mohammed in Abuja, directly, and as I was saying, Ada's point was that that I wanted you to comment on was that all of this wahala, so to speak, is really as a result of what she referred to as a lack of internal democracy among the parties. That if there had been that in the first instance, all of this wouldn't have come about. Mr. Lawal.
Internal democracy. The party decided to have a caretaker committee, which the PDP also had at a point, and decisions were taken. Mai Mala Buni was the head of that caretaker committee. Those matters had been settled even by the Supreme Court, that an executive position cannot be equated with a position that is temporary. That was, decided in Shinkafi and Makarufi. Supreme Court had decided that caretaker committee is also legitimate for a political party. And what is more, when the party had its, national convention, the first thing they did was to ratify all decision of the Buni-led caretaker committee. It was democratically done. So the issue before the court was not whether Oyetola was properly, nominated by the party. That's not the issue. The issue the PDP had was that the person who signed the nomination was Malabuni as the sitting governor, which matters had been resolved by the Supreme Court. Like I told you, the Supreme Court had settled that matter in case of Akeredolu and the case of Yita Ojegede and Akeredolu, and they have defined what sponsorship and nomination of political party is. So people rely on social media and newspaper, speculation that time that the reason why Yita Ojegede lost was because they didn't join Mai Mala Buni. And the Supreme Court even said that if there is going to be any consequence of Mai Mala Buni signing that thing, the consequence will be on it, because the law says you cannot hold two executive positions. Mm-hmm. If it is seen that you have held two executive positions, you will lose the first one you have held. So he would have lost his seat as a governor, even if there is going to be consequence, that the party cannot be made to suffer for such things. That was what the majority judgment said.
Okay, Mr. Lawal, I beg your pardon for interrupting you again, but these matters are such that I do feel I need to allow you time to sort of explain them, since there are legalisms and a few technicalities. So I'm sorry for interrupting you. There still is the matter of Mr. Mohammed, who called in from Abuja, that you heard directly, but in the meantime, Mr. Ogunaike has called in from Ijebu-Ode. So let's hear that. Good morning, Mr. Ogunaike. I hear that we've just lost that call from Mr. Ogunaike in Ijebu-Ode. So would you like to comment on any aspect of Mr. Mohammed's submission from Abuja? Mr. Lawal, can you recall? Yes. Can you recall, Mr. Mohammed's call from Abuja?
Unfortunately for me, as at the time Mr. Mohammed was talking, I lost you, so I had to reconnect. So I didn't follow his argument. Mm-hmm. That's why I didn't also want to comment on things I did not hear very well.
Okay, fair enough. And Mr. Ogunaike is back. Good morning to you, Mr. Ogunaike, calling in from Ijebu-Ode. Thank you for trying again.
Yes, good morning, Mr. Ayori for line.
Good morning.
God bless you. Yes, this is Evangelist Ogunaike from Djibouti. You see, I just want to talk about the ruling of the court concerning Governor Oyetola, nullifying him as a governorship candidate in the primary. You see, I think the court is the last hope of the common man, especially in this country. And the loophole is from INEC. INEC should have done their assignment properly before. They should have done everything clean and clear before even going to court. If they have done their assignment properly in the electioneering process and the nomination process, all these issues going to court here and there shouldn't have come to play. So INEC needs a law to be done in terms before election. They need to define their clear terms and make their position known to all the candidates, so that all these frequent occurrence of court cases and cases will not be coming up. That's my own. Thank you, and God bless you.
Thank you very much, Mr. Ogunaike. Well, a little knock, if you will, for INEC there, but this is against the backdrop of a lot of commentators saying that INEC has, really been on the ball. But however, Mr. Alabi, do you share, that criticism of INEC?
There is nothing INEC would have done in the circumstance, because the nomination was, INEC monitored the primary election in Osun. They wrote their report. They were there when the results were declared. Governor Oyetola was validly nominated. What would INEC have done to refuse to accept the nomination or what? I don't understand what people are saying. What I'm saying is that the case the PTP, brought to court, they are just meddlesome interlopers in affairs that does not concern them. How does nomination of Oyetola concern them when it was not even the party person, the members of the parties that are complaining that Oyetola was not properly nominated? And like I have said repeatedly, that the issue of nomination is the affairs of the party at the state congress. And it is only those who participated in that congress that can challenge if the primary is not well conducted. Mm-hmm. Those who, went to court did not even challenge, nobody challenged Oyetola's primary in court. The matter that they had in court was the constitution of the executives of the party.
Okay, let's hear it from Chris. Chris has called in from Jos. Yeah. Good morning, Chris, in Jos.
Hello, good morning, Uncle Yori.
Good morning, sir.
I want to contribute in this nullification of Oyetola's nomination.
Sure, go ahead.
Good morning, Uncle Yori.
Good morning, sir. I heard you the first time.
Yeah, I want to make a comment.
Go ahead, please.
Yes, the lawyer that you are entertaining there is turning the issue upside down. Okay, I said the man appearing before you is turning the issue upside down because the case between Jegede and Akeredolu, the judge was very specific. If Bala Muni was done in that case, then Jegede will have his day. You understand now? That as a governor, it was wrong, it was an error for you to hold two executive positions. So the issue was that Jegede and his team did not join Bala Muni in that suit. That was why Akeredolu retained his seat. So if Adeleke has gone to court, Adeleke has just taken a cue from the judgment that was given in Ondo State. So the man that is appearing for you is turning the issue is this sentimental. The issue is that Adeleke capitalized on the judgment of Ondo State to take Oyetola to court. So the court said Bala Muni cannot hold two executive positions at the same time. But in the case of Jegede Akeredolu, Bala Muni was joined in that suit, Akeredolu would have lost his position. That was the judgment.
Okay. Well, thank you for contributing that point.
I don't know whether that person is a lawyer. If he's a lawyer, it is unfortunate that he will make this comment. Is either he has not read the judgment itself, whether he relied on newspaper reports or social media reports. This is the judgment I am holding in my hand. Jegede and Akeredolu. There is no way. Let me quote what Paagim said. He said there is no doubt that Mai Mala Buni was elected as governor of Yobe State and remained in that office on behalf of himself and the second respondent that sponsored him as its candidate for the election, and that his right to hold office is not exclusively his, as it belonged to him and the second respondent, that is the APC, the political party on which platform sponsorship he was elected to and is holding that office. It does not make Section 183 applicable to the second respondent, that is APC. I am reading directly from the judgment because it is members that is holding the office that is executing the function of the office, presumably in pursuance of the second respondent manifesto, campaign promises and plan of good governance and development of the state. It is clear from the provision of Section 183 that if the government of a state holds any other executive office or paid employment in any capacity whatsoever during his tenure of office as such, governor, he or she ceases to hold the office of governor in accordance with the provision of the Constitution and cannot from that moment continue to hold the office of governor, therefore shall vacate same by virtue of Section 181D of the 1999 Constitution. So the contention that Governor Mai Mala Buni, as governor of Yobe, has violated Section 183 of the Constitution by holding the office of acting national chairman of the second is a very serious one with great concern for him, and no doubt for the second respondent as well. That number of that issue here will involve the enforcement of constitutional against and will certainly affect him personally, as I have shown above. If there is going to be any consequence, like I said, like I've read here, it is going to be for Mai Mala Buni alone by ceasing to be governor of Yobe State. It has nothing to do with the act he has done as the chairman, because if he's removed as the governor, he becomes an ordinary person and he will still be qualified to sign that document. So signing of that, that's what I have said. I have quoted from the decision of the court. I am reading directly from it.
The judgment.
I said that.
Okay. Thank you very much for that, Mr. Lawal. I beg your pardon, Mr. Lawal. I beg your pardon. Thank you very much for that clarification, especially reading directly from the court's judgment.
Directly from the judgment. I'm holding the judgment.
I hear you. Yes,
my hand.
Indeed. But I wanted to ask you in closing, some legal minds have begun to, as a result of this case, even begin to speculate as to how it would affect other candidates of APC, in particular, the presidential candidate of APC. You find some legal bigwigs and have been having a conversation about it, even though
I have also read the judgment. I've read the comment, and I was, embarrassed on their behalf. They should realize that the only nomination or the letter signed by Malabuni was in respect of the governorship election in Ekiti and Osun. Every other nomination that were done after the Congress of the APC, when the present leadership of the party had been decided. They were the one that, signed. These things are not far, away. They are a matter of some months that the thing happened. So it is embarrassing for any legal practitioner to begin to postulate that the decision in the wrong decision in of the Federal High Court regarding the nullification of the nomination of Oyetola will rub off on other nomination and presidency and stuff like that. It's to me it's absurd.
Thank you very much, Mr. Lawal. I can see that you're even getting a bit.
The party had been well constituted.
Okay.
The nominations were signed by the chairman and the secretary of the party.
I've got to butt in because I think you've been very, very clear about that, sir. Thank you very much. That this in no way, in fact, you've said that you were surprised that legal minds would engage in any such conversation and that it has nothing whatsoever, could not possibly touch on the perfection of the situation of Asiwaju's candidature. Thank you very much. And also for taking the time to sort of explain to us the intricacies of the whole Oyetola case as delivered by Justice, by the judge of the Federal High Court there. And also saying that you are optimistic that there are opportunities to explore once you get to a higher court. Thank you very much. Mr. Ibrahim Lawal is one of the counsels to Governor Oyetola. Mr. Ibrahim Lawal, a lawyer and public affairs analyst. Thank you very much once more for coming on the program. That's our program today. Do please join us tomorrow for a fresh edition. I am Yori Folarin. Bye-bye for now.